First matter to come before the court this morning is State of Ohio versus Tony Mavrakis. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock and can keep you apprised of the passage of time. The court's read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the court. Attorney Neil Iredell on behalf of the appellant Tony Mavrakis. I request 5 minutes for rebuttal. Your Honor, may it please the court, I'd like to proceed first to the fourth assignment of error because it's extremely important and I want to make sure I have enough time to discuss this. My client was convicted of a number of charges and he was acquitted of 2 charges, including felonious assault and breaking and entering. Judge Hunter, as a visiting judge, sentenced my client, and during the sentencing hearing, she said that even though a jury did not find Mr. Mavrakis guilty of felonious assault and vandalism, that she thought about those charges, how important they were and the factors, and then she said, and I bolded this on page 14 of my brief, I simply cannot discount what happened at those places. That is indicating to the defendant that the judge considered acquitted conduct for purposes of sentencing. In other words, it was a sentencing factor used to determine his sentence of 7 years. Now, we are arguing that is a constitutional fundamental right, violation of his right to a jury trial for a number of reasons. First, you go to jury trial because you want the state to present its case beyond a reasonable doubt, and if they cannot, the jury has a right to acquit, which they have done in this case. If a defendant exercises his right to go to trial and is acquitted of some charges, how can a trial judge say, even though you were acquitted, I'm going to consider those actions for purposes of your sentence? You would in fact violate his right to go to jury.
When she's talking about, I simply can't discount what happened in those places. Which places, plural, is she referring to?
There were 2 incidents that occurred on the same day, Your Honor. She's talking, he was convicted of the occurrences that occurred at the first incident, of the breaking and entering into the home. But then there was a second incident that occurred like at a gas station that he was acquitted of. Okay. And that's when she's saying at those places, she's saying what happened at that second incident. So here the trial judge said that I'm going to consider those acquitted conduct for purposes of sentencing. Now, both the U.S. Supreme Court and the Ohio Supreme Court has stated that you cannot consider factors for sentencing if not found by a jury. In fact, both the Ohio Supreme Court, in a case that just came out after the briefing of the arguments, which I have filed a supplemental brief, State versus Bevy, 2015, Ohio 475, that came out February 11, 2015. On paragraph 23, they say, when a finding of fact alters the legally prescribed punishment so as to aggravate it, the facts necessarily forms a constituent part of the new offense and must be submitted to the jury. And this is very important, the next sentence. It is no answer to say that the defendant could have received the same sentence with or without that fact. So what the court is saying is even if the defendant would have received the exact same sentence, if you took out the improper factors, it doesn't matter. It's still a violation of his constitutional right.
Can I interrupt you?
Yes, Your Honor.
The facts are not entirely clear in my head in the sequence, but in this count in which the jury acquitted the defendant, were any of those facts necessary for the conviction on other counts of which he was convicted?
No, Your Honor.
All right, so you don't have that confusion.
Correct. They were they all occurred on the same day, but they were in completely separate locations.
All right.
Okay.
Tried in the same court by the same judge at the same time.
Correct. Yeah, in all 6 counts. He was acquitted of the ones that happened at the second act. He was convicted of the ones that occurred at the first act. The Ohio Supreme Court went on to say, if a judge were to find a fact that increased the statutory maximum sentence Such a finding would violate the Sixth Amendment, even if the defendant ultimately received a sentence falling within the original sentencing range. So, what that indicates, I would ask this court to indicate, means, is that if a court considered improper factors, if the sentence could have been the same even without considering of those improper factors, he's still entitled to a new sentencing because we don't know how much of a factor the court gave to those improper considerations. If, for example, the trial judge said, well, you are a Muslim, or you're black, or you're a man, or whatever factor, and I'm going to take that into consideration as part of your sentencing, I don't think this court would have any hesitancy to say that's improper. You cannot look at these other factors and say, what is his sentence? Now, the state in its brief basically says, so what? So what if the judge considered these acquitted conduct? Because he still got a sentence for the maximum between 2 to 8 years. He got a sentence of 7 years. So you can't show that it had any impact on the sentence. He didn't get the maximum. The judge mentioned the other sentencing factors, looked at everything. So you can't show, the defendant cannot show that it had any impact whatsoever on his 7 years. However, that's not the standard for this court, is did the court consider improper factors in sentencing? Again, it doesn't matter if the defendant would have received the exact same sentence if you took out that consideration. All right? So I would ask this court to reverse and remand, and you have to remember, Your Honor, if a defendant goes and exercises his right to go to jury trial, if he's acquitted, you know that you're going to not get sentenced or punished for state evidence of crimes that could not be proven beyond a reasonable doubt. So why would you go to trial if you could be punished anyways? It would make no sense to go to trial if the judge can say, even though you're acquitted, I'm going to look at these factors. I'm going to consider the acquitted conduct and then punish you for it, or at least increase the sentencing that I can do for it. Now, briefly I want to talk about my last assignment of error. Because there is a sentencing statute, 2929.19b2f, that says when you send someone to prison, you have to notify them that they are subject to random drug screens and is not to use illegal substances while in prison. Now you may say that's pretty self-evident. However, the statute specifically requires at sentencing a trial judge must inform the defendant of that. This court has reversed and remanded to give that colloquy to the defendant at time of sentencing. That was not done in this case, so I'd ask the court to reverse and remand to give him that colloquy. For my first assignment of error, my client is convicted of aggravated burglary by trespassing with a weapon and committing a crime therein. The fact that this case shows, Mr. Mavrakis went to this woman's home, was banging on it for 2 to 3 minutes, trying to find her grandson, who basically took his car, my client's car. While he was banging, the grandmother's son went and unlocked the door. My client then proceeded into the premises, asking where the grandson was. The woman and her son are saying, we don't know where he is, we can try to find him. And he proceeds to really trash the place. He ended up destroying a number of artifacts on the wall.
Is he the guy with the bayonet?
Yes. He had a bayonet. He committed vandalism, there's no doubt about it. No one disputes that, and that's not what we're appealing here.
Who opened the door?
My client did. And the sequence of events is very important here. He's knocking on the door or banging on the door, however you want to say it, for 2 minutes or so. The son goes, unlocks the door. It's a big glass window, so it's not like you couldn't see what was going on. The son unlocked the door, did not physically slide open the door or open it. And then my client, once it was unlocked, entered the premises. Because of that sequence of events, we're saying it was not a trespass into the building or into the home.
So he read into the unlocking of the door some sort of permission to enter. That's your position?
That is our permission. It was an implied grant, if not an express grant. Because if you're knocking on a locked door and you see the person inside the home unlocks it, well, why are they unlocking it? What is the mechanism? What was the thinking to my client? If you're unlocking the door, then you're giving at least an express, you're giving an implied permission, if not express permission, to enter the premises.
And you just now reached your 5 minutes remaining.
And I would argue, based upon that there was no trespass. Now, he's still guilty of the vandalism and everything he did inside the premises, but you can't take, when you take out the trespass, if I can make this court feel that there was no trespass, the aggravated burglary would go
Well,
up.
let me just ask you, let's assume the door was never locked, and he's banging on the door, and somehow he discovers that it's not locked. He doesn't have an implied permission to enter.
I would agree in that, right,
You would agree?
I would agree.
And if grandma yelled at him, don't let him in, even though he unlocked the door, hypothetically.
Well, if
Is he have
there's,
permission then?
if there's two people and one unlocks, and would a slide the door allow him in, even if the other person is saying don't, that would be an implied, I would say. So if there's two people and one does and one doesn't, I think you could infer from the one who did open the door that he could enter.
So let's take this just a stitch farther. He unlocks the door and he opens the door. Is that an implied entry, implied permission to enter? He's standing there with the door open?
I'm sorry, who opened it?
The son.
Okay.
That still wouldn't be an invitation to enter.
Well, if I'm knocking on the door and you see me and I'm saying I want to come in, and you unlock the door and open it, I would think that I'm free to enter. So I would argue that would be an implied grant at least. So I would reserve the balance of my time for rebuttal. Thank you.
May it please the court, Kevin DiMartino on behalf of the state of Ohio, the appellee, we are asking that this court affirm. Just starting in the order that the appellant's counsel started with the fourth assignment of error, the state would argue that when you read the entire sentencing transcript, it is clear that the trial court did not sentence Mr. Mavrakis based on the acquitted charges. The court said, clearly, I'm not sentencing on these counts, and then goes on to say that when the court was making consideration as to the likelihood for recidivism, that she could not discount those things. So the sentence itself, the 7 years, was based on the charges in this case and the facts of this case, which were that Mr. Mavrakis showed up at this residence with a bayonet that he was wielding and attempting to get into the residence. The evidence showed that the son, who had schizophrenia, unlocked the door. I'm not sure that it's clear from the record how Mr. Mavrakis knew that he was unlocking the door as opposed to locking the door. But either way, there's nothing in the record to show that when that door was unlocked, that was an invitation for someone with a bayonet screaming and yelling to enter. And the whole idea that if you unlock the door or even you open the door, that that's an invitation for someone to come in is, quite frankly, a frightening concept and unusual for a defense attorney to be making, because certainly when the police come to the door, if they wanted to talk to somebody, if they knocked on the door and you unlocked it or you opened it a little to see who's out there, that would not be an invitation for the police to come in and search your home. It's such an illogical conclusion to make that if out of fear because I had a rental property, someone was banging on the glass and I have some mental disease or defect such as schizophrenia, I don't know whether he was on his meds or not on his meds, if all I was worried about was he's going to break the glass and I'm going to be in trouble with the landlord, so I unlocked the door thinking that will somehow prevent the glass from breaking. The stretch that that's now an invitation for this man with a bayonet to come in, it's just not in the record, and it's just not a logical conclusion, and it would be, in my opinion, a very dangerous precedent to set as far as that's implied consent anytime somebody unlocks the door and somebody starts to open it.
Or leaves the door unlocked.
Or leaves the door unlocked, exactly. And in this case, it was not the son who opened the door. There's no dispute in the record. All he did was unlock it. And we can all sit back and say, why did he unlock the door? But in a situation like that, we know everybody, their reaction is a little bit different. And this individual was under a different circumstance with the schizophrenia as well. With regard to the argument that appellant makes with regard to the Beverly case and the fact that the court erred in considering these factors, the Beverly case is not on point at all. That case dealt with gross sexual imposition and the two sections of the statute where if you have corroborating evidence that requires mandatory time and the other section does not. And the court said there it doesn't make sense if you're going to have the court making a finding of fact, which would be the corroborating evidence, which would put a defendant into a mandatory prison time situation as opposed to one who did not. And that was going back to the Alliann case, which is what opposing counsel was reading from, which was that would not change the fact that they would have gotten a sentence, would have changed the fact. But in this case, the court did not make a finding of fact that was necessary to enhance the penalty. The court looked at the sentencing factors, imposed a sentence, and then clearly stated that the court was not relying on any of the acquitted charges for the sentence, but did consider them, felt that she had to consider those things just with regard to recidivism. Is this person...
Did the court say, I'm not considering any of those things that happened at the gas station, or did the court say, clearly I'm not imposing sentence on those charges? Because clearly
She said, clearly I'm not sentencing on those counts. And then she went on to say, when I think about likelihood to recidivism factors, I have to consider these other things. And I think that the court can say, here's the conduct. Just because that person was acquitted doesn't mean that there wasn't enough in the record for the court to say he went on and did some other things, just because they were not beyond a reasonable doubt. It just went to the fact of, is this person a danger to society? And clearly, even if you take that out, that 7-year sentence, you can tell the court came up with that number based on the fact that he went to this house, it was people he knew, he had the bayonet, he let himself in, did all of this damage, and he was a danger to other folks. And it's not really clear how much the court considered the other factors as far as even recidivism goes, because based on those events, I think you could say that this person would do that type of thing again.
Well, is there a difference between, let's assume that he was never indicted, charged with anything related to a separate incident, and it comes time for sentencing, and the court is sitting there looking at the PSI and hearing everything that's happened in this person's life. Is there a difference? Could the court then rely on what happened at the gas station? I just keep simplifying it for that.
Right.
But if he was charged and acquitted, is the court even allowed to consider that behavior at all?
I think because this court heard the trial, the court was aware of those things, and honestly, I don't recall if any of that, if there was a PSI, if that was in the PSI off the top of my head, honestly, I don't know. It could have been in the PSI anyway.
Right.
But I understand what you're saying, is once you bring that into trial and you're exercising your right to trial, should the court even be allowed to consider it? And if this court says the court shouldn't have even mentioned it, thought about it at all with regard to danger to society or likelihood to commit future crimes, that still is different than the Beverly case, because the court was not making a finding of fact to enhance a punishment like it did in Beverly. This was just a court saying, I'm not considering that as a sentencing factor. I'm not sentencing you on it, but when I think about what type of danger do you pose to society, I can't discount the fact that I heard this testimony about it, in addition to the very violent type of behavior that was here with regard to the underlying charges.
So then the state's position is that the trial judge doesn't have to forget everything that the trial judge heard, regardless of the outcome on particular charges.
As long as they're not sentencing on those counts. If they're considering it just as an overall, what this defendant's propensity is, or are they truly a danger to society? Is this an isolated incident, or did I hear other things at trial that make me think this person is more dangerous to society, more dangerous to themselves? And I think the court should not have to forget all of that, as long as they're not imposing a sentence for charges that were acquitted. If there's nothing else, I would rest on the brief, and I would ask this court to affirm the conviction and sentence of the trial court.
Thank you. Counsel, you have just under 3.5 minutes remaining.
Thank you, Your Honor. May it please the court. Your Honor, I want to go back to what the trial judge said at sentencing. She did say, you know, I am not sentencing on those acquitted counts. But then she goes, I simply cannot discount what happened at those places. So she's saying, the jury found you not guilty, but I'm not going to forget what happened at that, and I'm going to take sentencing and I'm going to consider the acquitted conduct.
Why did I get the impression that there was a prior felonious assault, an F1 or something, that assault on a police officer that was being considered that you're asking not to be considered? Why did I get that impression?
Your Honor,
It's the first I've heard of a gas station for that.
I'm sorry. In my third assignment of error, for purposes of sentencing, it was a mandatory sentence. And the reason the trial court imposed a mandatory sentence is because the prosecutor said at sentencing he has a prior felonious assault on a police officer.
Okay, and wouldn't that be one of the things that she was considering?
That is to be considered for purposes of the mandatory sentence. But I guess what I'm saying here is the trial judge is saying, I am considering the acquitted conduct for your sentence of 7 years in this case. And case law after case law has said that a trial court may not impose a sentence upon crimes that are neither charged nor proven. Our criminal justice system does not permit the court to impose sentences for crimes which charged but which are not proven beyond a reasonable doubt.
What if they were crimes that were never charged, and they ended up in the court's mind at the time of sentencing?
Well, assuming that we can prove the judge considered charges, again, if it's not been charged nor proven beyond a reasonable doubt, a trial judge cannot consider those for determining that sentence.
Well, at sentencing, doesn't the trial judge consider a lot of information received for which the defendant has not been convicted?
Yes, I mean, like if they have children, if they're married, their prior history, yes, absolutely. But acquitted conduct is not one of them.
So then, your argument is once you've indicted and tried, if he gets acquitted, then the judge cannot consider that conduct. If you've never indicted, if he's never been tried on something,
You still can't consider
you
that.
still can't consider it.
Right, let's say hypothetically he committed domestic violence, or there's allegations he committed domestic violence. It was never indicted, he's not charged, he's here for sentencing. The judge can't say, well, I heard that you might have committed domestic violence on your mother or girlfriend, so I'm just going to tack on, or I'm going to consider that conduct. That's not before the court. It's just as improper as if you went to trial on a DV and was found not guilty. Can the judge say, well, I don't like the fact that you were charged with DV on your mother, so I'm just going to increase your sentence based upon the stuff you were convicted of. I mean, you still can't do that. He can only be sentenced upon the facts as found by the jury.
Well, okay, so on your DV, if he, at the time of sentencing on this case, was indicted and if he was charged with DV, but nothing had proceeded in that case yet, the court couldn't consider the fact that he had another criminal charge pending?
No. No, because he hasn't been proven beyond a reasonable doubt. The jury hasn't found him on those. How can those be sent? What if he's acquitted of it at trial, on a separate trial? Can we say, well, his sentencing was proper because he's only accused of it? They're only accusations. He's still innocent until proven guilty. So, respectfully, I'd ask the court to reverse and remand, unless there's any further questions. I'll rest. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.